All right. I think we are ready to begin. Good evening and welcome. My name is Ben Pringler, and I'm the Executive Vice President of the Texas Federalist Society this year. I could not be more thrilled to introduce our speakers for our event, Judicial Nominations Past, Present, and Future. But before I do, I implore you, if you are not already a member of the Texas Federalist Society, to go to our website, texasfedsoc.org, to join. Now for introductions. Judge Southwick is a judge on the United States Court of Appeals for the Fifth Circuit. He graduated cum laude from Rice and received his law degree from Texas Law, Hookham. After school, he clerked for Judge Onion of the Texas Court of Criminal Appeals and then with Judge Charles Clark of the Fifth Circuit. After those clerkships, he worked at a large law firm in Jackson, Mississippi, and then served as a Deputy Assistant Attorney General in the Justice Department's Civil Division. From 1992 to 2008, he served in the JAG Corps, in the United States Army Reserves, and in the Mississippi National Guard. In 2007, Judge Southwick was nominated by President George W. Bush to serve as a judge on the U.S. Court of Appeals for the Fifth Circuit and was confirmed later that year. Andrew Davis serves as Chief Counsel to Senator Ted Cruz. Before his role in the Senate, he was an Assistant Solicitor General in the Texas Attorney General's Office and an associate at a law firm in Washington, D.C. Before that, he clerked for Judge Raji of the Second Circuit and Judge Fitzwater of the Northern District of Texas. He is a graduate of Rice University and Columbia Law School. We'll begin with a discussion of nominations after work, what that process looks like today, and then what we can expect the process to look like in the future. Each segment will be about 15 minutes, and I'll try to keep us on time. And at the end, we will have time for questions. Gentlemen, thank you for joining us. Judge Southwick, will you kick us off?
Well, you, Ben, have labeled this first segment as post-Bork, so I will perhaps bend the rule just a bit and talk about Bork briefly. It has been said that if he had been nominated a year earlier, he'd have been on the Supreme Court. Reagan had a Republican majority in the U.S. Senate for 6 years. The last 2 years, Democrats had a majority. Scalia and Rehnquist were confirmed in 1986 for Chief Justice and to take Rehnquist's place as associate. Bork came up the next year after Democrats had taken control. So some speculation if Scalia had been held back, Bork go forward. It may have worked out for both of them. Of course, the risk there is we may have lost Scalia. So who knows? But it did become much more noticeably politicized, I think, with Bork. He was not exactly the first Supreme Court nominee to face difficulties, but it did seem to have a viciousness to it in 1987 that had not existed before. So Bork was not confirmed. A little bit of a forgotten footnote of that time, Doug Ginsburg, the other Ginsburg on the D.C. Circuit, was selected thereafter. He was withdrawn because of complications. And then Anthony Kennedy was nominated and confirmed. I was in Washington, as Ben said in his introduction, in the first Bush presidency. Those of you who have been involved a little bit in understanding federal government will understand the longer your title in an administration, the less influence you have. Modifiers keep being added to your title. I was a Deputy Assistant Attorney General. I could be found in the main Justice Building, but I wasn't in the penthouse suite by any means. But I was somewhat familiar with nominations at that time. I'll start with the statement that on that aspect of it, that there's never been a Fifth Circuit Court of Appeals judge on the United States Supreme Court. Now, I don't know how many of the other 11 numbered circuits would also have that shortcoming, but we never have. We've had several people come close. And one of the things that perhaps the Federalist Society is particularly aware of is the first vacancy under the Bush 41 administration on the Supreme Court. I think it was Justice Brennan, but regardless, David Souter was named to that vacancy. When the vacancy arose, people were summoned to Washington. Two people were the finalists. One was Souter and the other was Fifth Circuit Judge Edith Jones. Both met with President Bush. I think later that day, Bush decided on Souter, and the rest very much was history on the Supreme Court. Judge Jones has had other chances. She'd have been terrific, but of course never got there. Another Fifth Circuit judge was considered when Clarence Thomas was nominated after Thurgood Marshall had to retire, and that was Emilio Garza. He also rushed up to D.C., but was not selected. Obviously, an excellent justice was selected instead in Clarence Thomas. Interesting, under Bill Clinton, the only vacancies that arose is during his first 2 years. And that was because of resignations by people who wanted, I guess, a Democrat Supreme Court appointment. And there were no more vacancies after that, but the GOP had control of the Senate thereafter. Rather than talking about Supreme Court nominees under this Bush 43, I want to talk about what I'm particularly aware of, which are Fifth Circuit nominees. The first nominations were made on May 9, 2001, reflected in a national broadcast from the East Room. I can't quite remember which room it was in the White House, where 11 people, including John Roberts, were standing on bleachers, risers probably, in that room being announced by George W. Bush that they would be nominated. About a month later, the Republicans lost control of the Senate, which was 50-50. Was Vice President Cheney breaking the tie? Well, one of the Republicans left the caucus and they lost control. So things really stalled thereafter. First 11 were confirmed immediately, and it took several years. John Roberts, for example, wasn't confirmed until the second Congress under George W. Bush, and others came along later. To me, the increasing politicization, I got too many syllables there, I won't try it again, of nomination process. I became particularly aware of it in the George W. Bush administration because I was in the middle of it, but I also think the numbers reflect that. And looking again just at the Fifth Circuit, from the first Fifth Circuit nominees back in the 19th century until 2007, only 3 Fifth Circuit nominees ever got negative votes, not just defeated, got negative votes even on the floor of the Senate. Everybody else was unanimous consent or maybe a roll call vote, and it was unanimous. Usually there's no roll call vote. But 3 people had. The second one was Priscilla Owen in 2005, who is now the Chief Judge of the Fifth Circuit. Now is the third in 2007. No one else got negative votes who was nominated for the Fifth Circuit under President Obama. But then when in 2017, every single nominee for the Fifth Circuit has gotten an enormous number of negative votes. 3 of my colleagues out of the 6 that were nominated during that administration, 3 got no Democrat votes, 1 got 1 got 3, and somebody else got a landslide of about a dozen who had been a district judge for a while, and I guess was seen as had more friends than the rest of them. So to me, what's going on post Bork, and to some extent Bork was sort of the early indicator of what was ahead, is because of the increasing concern or increasing sense that the courts are a major player. They're not the least important branch anymore, but are a major player in our government. The judicial nominations have become much more controversial than they were. Started at the Supreme Court, but now has worked its way down at least to the circuit level. And I think in some places, even district judges are somewhat contentious, so that is still in a quite limited way. I don't want to take more than half of this time period, so I'll turn it over to Andrew.
Well, thank you, Judge, and it's an honor to be on this panel with you. I think you also undersell your experience in the Department of Justice, where the Deputy Assistant Attorney General is a fantastic role, very important. For those of you who don't know, they run very important divisions, and I believe, if I remember correctly, Judge Southwick, you ran the federal programs branch, correct?
Best branch in the Justice Department. Yes.
Yes. And so the federal programs department defends all of the executive actions and all of the regulations that come across the government. So it's an immensely important job. So it's one that any lawyer would be lucky to have. So being very modest there. And but it's a pleasure to be on this panel with you. I think the judge is absolutely right that the process has become much more political because the stakes are being viewed as much higher. You're getting situations where people believe, rightly or wrongly, that a lot of issues that are going to be coming across that they would traditionally think of as issues that would be resolved by legislatures or by Congress are instead going to be resolved by the courts. whether that's a district judge, whether that's a circuit judge, or ultimately the Supreme Court. And so you have seen a trend where you're going to have much more contention at every level of the nominations. And this really began with Bork, but it's really been increasing almost exponentially over the years. You're even seeing high contention with district court nominees, and that's a function of a number of things, and including the fact that with nationwide injunctions, a single district court judge has the power to enjoin priorities of the administration, whether that's a Republican nominee or a Democrat nominee enjoining a Democrat's president's preferred policies, or vice versa, as we saw in the Trump administration when you saw injunctions come out of the Northern District of California from San Francisco or Hawaii that enjoined policies that President Trump had put in, or as you're seeing now when some Texas judges are putting in injunctions against policies that President Biden has been enacting. And because of that, you're getting contention not only at the Supreme Court level, but you're getting it across the board. And I think Judge Suffolk is absolutely right that the contention has increased even in the circuit. That happened a little bit later with Bork in the 80s, and then the circuit's really taking hold in the 2000s. And some of the names he didn't mention from sort of the 2000 area, Miguel Estrada is one that was set up and was someone who was potentially seen as a Supreme Court pick. He would have been the first Hispanic individual to be on the Supreme Court, but his nomination ended up failing. And this is a time where there was still the filibuster, and I think that's an important piece to keep in mind, is the filibuster still remained for all judicial nominees during the 2000s. And it was nearly blown up at multiple pieces of time. So you'd have a group of, I think there was a gang of 8 or 12, I can't remember the exact number, that came together to preserve the filibuster by agreeing on certain nominees and jettisoning others. And that allowed to preserve the filibuster for the time being, at least. But of course, we know that wasn't to last either, because we've really seen the escalation that's been climbing in terms of the heated passions when it comes to the different roles and the different beliefs of different judicial philosophies trying to get different judges along. And so it's absolutely right that the change has been increasing. And you mentioned some numbers, and I've got some that I pulled together specifically from how it's even changed from the Obama administration to the Biden administration, to the Trump administration, I should say. So in the 114th Congress and 113th, this is the 2 terms of Congress for the last 4 years of Obama, there were 24 circuit judges that were nominated. Only 5 of them were voted on party line in the Senate. So at least in some R's voted for nearly 83% of Obama's circuit nominees during that time. More than half didn't even have a single Republican vote in opposition. And that's for circuit judges. I'll say again, more than half of the President Obama's circuit nominees didn't have a single Republican vote in opposition. In Trump, during the 115th Congress, that's the first 2 years of the Trump administration, 19 of the 24 were party line. And it just increased from there. Only 7% of President Trump's circuit nominees had no Democratic opposition. So that number had moved from basically a very high number down to 7%. So that's just showing how the trend has been to make these things more and more party line. And you saw that especially with Justice Barrett during her confirmation process, when in the committee vote, you had the Democrats who didn't show up. They decided to boycott the entire process. And that just shows how controversial the process has become and how far it's moved since the days of Antonin Scalia, who was no blank canvas. Everyone knew what he believed. It wasn't a secret. But it was back then you could do those kind of things. You had someone like Justice Brennan, who was very clear, and Justice Douglas, who was an avowed progressive, and they all were put on the court. Everyone knew their views, but it's since changed, and it's become something where ideology matters very much to both sides of the aisle. And I think this road from Bork to now is something that has really changed how judicial nominations happen and the politicization of them.
All right, I think that puts us just at the end of our first segment on the process post-Bork. I do see some questions rolling in, and that's fantastic. Do we want to answer some of those questions now, and then maybe just have a shorter time at the end, or are you all okay with that?
I'm willing.
Whatever you want to do.
Why don't we take some now and sort of sprinkle them through the process?
Let's do it. All right, so the first question is, what, if any, are the pros of the process becoming more political?
Let me jump off on a bit of a side note to that, which comes with the filibuster, which I think is an important point. And there was a time between Bork and probably Gorsuch is the last one, where because of the filibuster, you wanted to have nominees that weren't appearing to be political. And I don't say political in the sense of Republican versus Democrat, but ideological, I should say, where you're going to have the different parties come with supporting their candidate versus another. Chief Justice Roberts is a very good example of this. He was someone who didn't have a lot of writings. He was considered not to have been wading into the controversial issues of the day because he had to get 60 votes. He had to overcome a filibuster, and that was sort of the mold of a lot of the nominees. Since then, with the breakdown of the filibuster with Neil Gorsuch, when the Republicans invoked the nuclear option and removed the filibuster from Supreme Court nominees, it had been under the Harry Reid Senate, it had been removed for circuit nominees. You now had a situation where Republicans were going to demand nominees that had a proven conservative track record. And you're going to see nominees from Democrats that have proven progressive or liberal track records. And that's because no longer are people trying to count to 60, they're trying to count to 50. Now there's some downside to that, but there's also upside. The upside is that it's more of a referendum on the actual ideology and what that judge will be. Before, it was purely, or at least when you didn't have judges who had a lot of writings, who were clear on what their ideology would be, it was a little bit of a gamble. And people didn't know exactly what they're going to get. And if you believe that in the system, the whole idea of a confirmation process is to actually understand what people believe, to understand who you're putting on the bench, what type of approach they'll have to the law, having that more of that transparency is a better thing. It doesn't mean that it's particularly transparent now. We can talk about that later in terms of how it's very opaque still in terms of nominees not giving clear answers to things. But there's at least a little more transparency in what you're going to get that I think is, what you saw pre-Bork is somewhat returning now with the drop of the filibuster. I think the difference, though, of course, is pre-Bork, everyone sort of got through on the idea of if you're qualified, your ideology didn't matter. Now there's a focus on making sure that the nominees have the right sort of ideology. I want to say, again, in judicial sense, not in terms of playing for Team R or playing for Team D.
I won't take much more time with this question, and how could I add much to what Andrew said, but just one example of that. I mentioned Edith Jones and Souter as both being considered in 1990. I don't know the person who wrote this, I forget where it came from, but not long after she was not selected and Souter was, they said that one of the reasons she was passed over is she'd been on the Fifth Circuit for 5 years, which may not sound like very much. She was nominated when she was 35, so I imagine some people watching this should look forward to judgeships in the next 3 or 4 years if they want to match that schedule. Was nominated, confirmed a few days after she turned 36. But the argument was that her track record, her record as a judge was already 5 years long. She had made some decisions that would be used against her. She might have better opportunities later if the Republicans had control of the Senate in the future. So she was passed over very much for the kinds of things Andrew was talking about, that she had expressed or exhibited something that would be called an ideology that could be used against her. So that was 1990. People were not being filibustered yet, but still, her brief record held her back.
And I should add one interesting note about the filibuster here is that it wasn't immediately post-Bork that the filibuster was something that people had to overcome. What's memorable about Clarence Thomas's confirmation is that even though he didn't get 60 votes for confirmation, he was able to clear the filibuster. There was still a understanding back in that day that you could vote to end debate, because that's what the filibuster is. You're voting to end debate. It's called a cloture motion. You can vote to end debate and to bring it to an actual vote on the merits, which only requires 51. And in that time, people were willing to do that, vote to close debate, but then vote against the nomination. Nowadays, that is not something that happens. If you are going to vote against the nominee, you want to prevent them from getting an up or down vote. So that you need to clear 60, at least when the filibuster was there. And that's the same with legislation today. It's very hard to get to the merits of a vote if you can't close the filibuster.
I think that would bring us up to our next segment, which is what the process looks like today. Andrew, do you want to kick us off on that?
Sure. Let me talk a little bit about, to back up a little bit about how the nomination process itself works. Because a lot of times what you end up seeing is, and I know Judge Shuffle can talk a little more about this in detail from his own experiences, but the process from people who are on the outside looking at it see is oftentimes just, oh, someone was confirmed, or when it comes to a Supreme Court nominee, they see the confirmation hearing, and then some magic happens and there's a final floor vote. But there's a lot to the process nowadays because of the increased vetting of judicial nominees. I know the time it takes to get from the initial stages of vetting and putting someone in the process to confirmation is much longer than it took, say, in the 50s or 60s, where you would get someone who could be nominated very quickly and they would sort of sail through the Senate. It's a very different time for judicial nominations. So what will happen is you get different states, senators have different processes for this, and we can discuss that separately. But they work with the White House to come up with names for nominations. And sometimes that's a collaborative process. Sometimes it can be kind of a combative process, depending on the mix of the members from the Senate, from the state, and the president, if they're of the same party, different parties, if the two senators from the state are of different parties or the same party. And eventually they settle on a name or not. But the president comes up, makes a nomination. That nomination gets sent to the Senate. The Senate then refers the nomination to the Committee of Jurisdiction, which in the case of judges is sent to the Senate Judiciary Committee. At that point, the nominee has been in vetting, where they have to clear a bunch of background to make sure they're fit for office. And then you have all the writings that are gone through. Everything the person has basically done gets dumped into memos that are reviewed by the committee. That includes cases that they've worked on, their most important cases, some of their personal aspects, anything they've written. It's a large trove. And then they're scheduled for a hearing, and they come before the Senate Judiciary Committee, and they're questioned. And for judicial nominees who are nominated to be on the district court, sometimes that's a very short hearing. It's 5 of them together. For circuit judges, usually a bit longer because it's usually only 1 or 2 on a panel, so they get more questions. And then, of course, for a Supreme Court nominee, you're going to have only 1 person on the panel. So they're there to field the questions, and every senator is going to show up and take their pound of flesh, so to speak. Once they move through committee, they've had their hearing, then you're going to have a vote in the committee. And the committee has to vote and recommend whether to report the nomination favorably or unfavorably to the floor. If the nomination doesn't receive a majority of votes, then it stalls in committee and dies. It can't go to the floor. If, however, it receives enough votes, then it goes to the floor. And on the floor, that's where the filibuster used to come in, but now doesn't. What you would do is you file a petition for cloture to end the debate. You get 50 plus 1, and you then have another, after a little bit of time has to expire, but then you have a final vote on confirmation. So that's the lay of the land for the process. As it's happening in the Biden administration right now, we are seeing they're moving fairly quickly apace in terms of putting nominees up and through. I'm trying to remember the exact numbers. I had it up that I'd written down. I think they only have 5 nominees to the circuit judge, nominees to be circuit judges who have been confirmed. a DC Circuit nominee, 7th federal, a 2nd and a 10th, but they've got numerous ones sitting in the wings. A couple that have already been reported to the floor, so they've been out of the committee. They're now just waiting for their votes on the floor. And there are probably a handful, 4 or 5, that we've had hearings on that haven't had a vote out, if I remember correctly. But it's somewhere along those lines. So they're making progress in terms of putting more and more people out. It's been more of a priority than it was for them during the Obama administration. Obviously, during the Trump administration, it was a high priority. And one thing to think about as these nominees are coming through is that it's sort of in a priority time right now. The DC Circuit was the most prominent position to be filled, so that was the very first one that the Democrats filled. There was an open DC Circuit position. Ketanji Brown Jackson was the nominee, and she was confirmed. And they're going to work through the different circuits, especially in states where you're going to have friendly members of the Senate to the administration, right? So we've had one out of, I think, Illinois, one out of New York, because these are people who are going to work well with the administration because there are 2 Democrat senators and a Democrat president. The same thing happened in the Trump administration when you had Texas filled their seats fairly soon because it's 2 Republican members and you have a Republican president. Same with district courts. There are also a number of district court openings that are still open because of the Democrats' refusal to return a blue slip during the Republican Trump administration. And for those of you who don't know, a blue slip is essentially the senators saying, we do not approve, returning a blue slip, I should say, is saying we approve of this nominee. It's literally a blue slip of paper with the judge's nominee's name on it that the senator signs and gets sent into the committee. I've actually had a couple judges in Texas ask for their blue slip so they could frame it. And if the senators don't return the blue slip, they're essentially putting a veto on the nominee. And so, for example, in the District of Washington, the senators from Washington didn't return blue slips on nominees for the entire Trump administration. And so they had, I believe it was 3 open slots that were filled by President Biden. So they're going to work through those slots first, where they have open seats in Democratic states for a Democratic president to fill. And then they're eventually going to have to get to states such as Mississippi, which have an opening. And then you've got a situation in Texas. There could be a couple openings. You're going to get to red states. And that's when you're going to have much more negotiations and a little bit of infighting in terms of who the nominee is going to be. And there are different ways that different states can try to negotiate. In the past, I know, for example, my judge, Judge Raggi on the Second Circuit, talked about she was in New York back in the day. There was Senator D'Amato, who was a Republican, and then there was another senator who's a Democrat. And in a Democratic administration, that meant that the Democrats got 2 picks for every 1 Republican pick. And in a Republican administration, it meant the Republican got 2 picks for every 1 Democratic pick. That's one way you can do it, something along those lines. Another way is that you just come on compromise nominees, right? We're not going to put anyone up who's particularly progressive, and we're not going to put up anybody who's particularly conservative when it comes to judicial philosophy. So there are different ways that senators can approach this, but I think that's what's on the horizon is going to be some potential conflict between red state senators and the administration in terms of filling judicial vacancies, coming to decisions on those. And the last thing I'll say on that negotiation piece is the blue slips were blown up under the Trump administration for circuit judges. And I can't remember what year that was, but no longer would the committee hold up a nominee from the administration purely because the senators from a state didn't return a blue slip. And this allowed the Trump administration to fill seats in California and other places where the Democrats didn't want to have Trump nominees. And that will almost certainly happen again in this administration, where if we can't come to agreements on names, in terms of we meaning any Republican senators' offices, there very well could be a situation where they end up filling them with the people they want and blowing past the blue slips. What will be interesting to see is if they also break the blue slip rule when it comes to district court nominees. The Trump administration and I should say not the administration because they're not the ones who control it, but the Senate, controlled by the Republicans, held firm on judicial blue slips for district court nominees, which is why Washington, for example, had a lot of seats open. But it's unclear whether the Democrats will keep that tradition when it comes to, in a year or two when the seats they have left to fill are in Republican areas, whether they're going to still hold true to that or whether they're going to jettison that. It's an open question, and we'll find out. There have been some rumblings about them wanting to blow it up. I think there are some good reasons not to, even apart from me working for a Republican senator and wanting to have more conservative nominees. There's some prudential reasons why senators, even if you're a Democrat in a Democratic administration, wouldn't want that because it gives away your power. Right? A blue slip is power for you to stop your own administration from filling a seat with someone who you don't approve of, and you may have your own candidate in mind. So that's the lay of the land as it sits right now. I expect the Biden administration to keep pushing forward judges that my boss is going to have significant concerns about. He's voiced lots of concerns about the nominees so far, and they've been making a push towards more and more public defenders. I believe something like 4 of the first 5 circuit nominees were former public defenders, whether assistant public defenders or the public defender. They're making pushes on those ends as part of their sort of different theories of judicial interpretation and what they're looking for in judges. And I expect that to continue, and I expect my boss to be opposed to the vast majority of them. But that's where it sits at the moment.
Andrew is certainly much more aware of what's occurring today than I would be. But to put a little bit of a personal note on this, and it's not what's going on today, but what I went through that's somewhat responsive to the sorts of steps that Andrew was talking about. In Mississippi, for decades, there's not been a committee, there's not been a group of people beyond the 2 U.S. senators who make recommendations to the president on both district and circuit judges. And that's how I got, first step anyway, of where I am now. I remember being in the Bush 43 administration, first years, I remember 1989, and the senator who was a fairly good friend of mine, Thad Cochran, who became relatively powerful as an insider in the Senate, was, I don't want to use too strong a word, outraged comes to mind, upset, let me put it that way, that the administration was saying that they wanted 3 names at least for each vacancy on both the circuit and on district court, which senators thought was very much getting into their prerogatives. So it is another bad word to use, probably jealously guarded by senators of their role in the process, but it's obviously an administration that needs to take the next step. And so there's a lot of back and forth on that sort of thing. I will also say that it can be a very long process. For me, it was a very long process. And you can miss out, and if you don't give up, keep at it. And I don't have many of my colleagues, I know some of them. I had to wait several sort of cycles of selections before they were actually selected. And sometimes that's in the nomination process. I think one of us mentioned already, Andrew or me, that John Roberts was nominated in 92, was not confirmed, got to make big money through the rest of the 90s, and then gets nominated again in 2001, doesn't get confirmed, gets nominated again in 2003. So Hogan and Hartson had to keep up with him for 10 years or so, and that's probably not the worst thing. When he got nominated for Chief Justice, he just had 2 years of circuit cases to worry about. Well, I think that may be the end of this segment. Ben, I'll turn it back to you.
Actually, speaking of that, I'm curious, what was the preparation for your hearing and for your nomination like? What was that like?
A lot of prayer. What you mean beyond that?
Yes, sir.
I really did feel my faith was being challenged. I tried to keep from getting angry over it all. What I saw as unfair, other people may well have seen as just honest disagreement. But I had 2 hearings. I was nominated first for a district judgeship in 2006, year before I was nominated for this. Got all the way through the committee process, got voted onto the floor. A bunch of us, 13, I think, were supposed to get voted on to midnight, 1 o'clock, 2 o'clock in the morning before they went into the last recess before the election, but didn't happen. I didn't do a lot of preparation for that hearing. And then I go to the moot court, murder board, whatever it is, with DOJ people, White House, others, about a dozen people, as I remember. Before my district judge hearing, there were 4 of us who were going to have a hearing at the same time. And it was brutal. I thought, what in the world are they doing all this for? And it ends up, one Republican senator was the only senator in the Judicial Committee meeting. They asked me, can I be fair? Something pretty complicated like that. And I answered and survived the experience, and off I went. Well, January of the next year, I got nominated again. I got my hearing in May. It was supposed to be non-controversial. My senator told me that the Democrats agreed I would make it through quickly. I'd be confirmed by Memorial Day. I didn't realize they meant a different year, but I thought it was Memorial Day that same month. But my preparation for that also included a lot of looking back over my cases that I had worked on that I thought might be controversial. It really was just 2 days or 3 days before my hearing, before any outside group came forward and announced a list of 5 or 6 cases on the Mississippi Court of Appeals, where I had been for 12 years, that I had voted on. A few I'd written, but the controversial ones were some I joined, identified them, and all of a sudden I knew at least what some of the opposition would include. And so when I got to the hearing, or when I got to my moot court with people from DOJ and White House, the questions were coming from that press release or whatever it was from one of the outside groups. I know Alliance for Justice had one press release, but some other group did essentially the identical list of cases. And it was helpful, and I got feedback mid-answer at times as to a better way to handle something, not changing the answer, but just trying to deal with it in a more effective way and an honest way. And at the hearing, it was kind of rough, but my preparation was difficult until I learned until I learned first it was criticism, and then secondly what those criticisms were. I must have looked pretty beaten down after the hearing, and one of the Republicans who was there, Orrin Hatch, sort of chased me down. I kept thinking that the last Democrat had asked me questions because there's only one on the bench at a time, but they're waiting in the wings, I guess, having their coffee or whatever they're doing back there. And as soon as one finished, another one came forward. So once there was no more questions, I raced out of there. But Senator Hatch chased me down and said, sorry about all that. I think you're going to make it. I don't know if he actually said that. That's what I hope he said. But I barely did. That was my preparation.
Wonderful. Thank you, Judge.
And I'll add one small thing in quickly, which is to say, I think that also highlights the fact that the nominations process is often not fair in terms of who gets singled out for hard hearings or special attention. Obviously, if you have controversial things in your past and cases you worked on, that's going to more likely indicate it. But there are people who have controversial things in their background who come out on a day, they have their hearing, and turns out there are multiple floor votes scheduled for the same time, or something big has happened in the news and all the members are out doing something else, and no one really shows up to their hearing, and so they don't get questioned, and so they fly under the radar. There are other people who, for some reason, there's some tick in there that shouldn't be that big of a deal, but it gets blown up by either an outside group, and then all the senators are there, and there's a misstep and a question, and all of a sudden that person is a focus of a lot of attention. So I think from what I can tell, a lot of it's seemingly random to the nominee, and it's a political process, and so it can not always be the most straightforward in predictability.
Of course, some of us deserve the criticism. I don't know what category I'm in, but I appreciate the comments, Andrew.
So now for our final segment, I think we'll turn back to Judge for what changes we can expect in the judicial process.
Well, since this is highlighted as post-Bork, I wanted to read something from Bork's memoirs. He wrote several books after his experience, but one in particular was talking about his confirmation or failure thereof. And among the things he said is lawyers and professors have been encouraged to think twice or 3 times about what they write. and he gets into what they do if you have an ambition to be a federal judge, and be careful about a number of things that you may be doing in your life. Andrew addressed that to some extent. Into the filibuster may partly have affected that, and to some extent you have to prove your bona fides now to some groups. With I think to be selected in some environments, you almost need a record that makes you more controversial when it comes forward to the other side deciding whether to vote for you or not. So I think that may be a dynamic in the future, that the kinds of individuals who might have been the radio candidates, maybe not the best example because of how it worked out, but the David Souters versus Edith Jones, because you think you might have a smoother path. But if you don't have the record that will satisfy those on the side that you think would be voting for you, that's a problem itself. And you may never get nominated, or if nominated, you may not be fully supported by the party of the president who nominated. I see a number of things that have changed through the 30 years or so that I've been somewhat involved with this. Andrew already mentioned the blue slips. Pat Leahy had been one of the most insistent that you needed both blue slips returned before you would get a vote, even on a circuit nominee. Andrew can correct me on this, but I think that is correct. I'm on a legal committee with a person who used to be a professor at the University of Wisconsin, who was nominated for that circuit, 2010, something like that. After being nominated, before she got voted on, there was an election, and one of the two Democrats in Wisconsin got defeated, and the Republican comes in January and does not return his blue slip. And Leahy would not let her get a vote in the Senate Judiciary Committee, in part because the senator was saying, well, she's not from here. She's from, I forget where she grew up or whatever, but had moved to Wisconsin to be a professor. I think the filibuster, is it really dead? Is it really over? I mean, one of the things is all that's really going on now with the filibuster is just adding to how slow the process is. We really saw this in the last year of the Trump administration, that every vote had to be first on the filibuster, and then you had to wait a certain period of time, and then you'd have a vote on the actual confirmation. So that really slowed things down. What are the outside groups doing? They really weren't around that much until the 80s. Now they've gotten much more numerous and much more involved with challenges to or support of whoever the nominee is. Something else that is usually controversial when a Republican is president, not so much Democrats, is what does the ABA do? I don't see the ABA as a significant overall effect in this, but exactly what their role is has changed. So what I see in the future, I mean, just looking at the cases we're getting in the Fifth Circuit as an example of how the law is affecting so much public policy right now. I thought I was on a vacation a few months ago, and we have a right as circuit judges, at least in the Fifth Circuit, to declare 2 weeks a year that we won't be bothered. We won't get emergency motions or whatever else. But I was only going to be gone meeting with families someplace Thursday and Friday and Monday. So well, I don't need to declare this is my respite. Well, Friday night at 10:30, I get an emergency motion on a pretty high-profile case out of Texas that they want a ruling by noon on Saturday. So I think the frequency of those sorts of cases, and we're all reading about them right now, will make this even more divisive in the future, even more insistent on both sides, that those who are being nominated, the supporters of that side of the aisle, will want folks that they have some trust in, who have proven in some way by their writings, by writings outside of judgeships or as judges, have proven that they are able to carry the banner, and then the opponents will find that even more off-putting and lead to things. So I don't see a fork in the road that I think is going to make much difference. How these controversies are handled how the controversies arise and exactly how they play out may change in the future, but I don't see any relief in the judicial process. There are certain issues that drive this. If some of them are resolved and taken off the judicial platter, one comes to mind that maybe you're thinking of. But if there are ways to sort of limit what courts have to do, or declare it no longer part of the Constitution or something else, that might soften the or lighten the load a little bit for those who are going through the process. But I don't particularly see that any meaningful, helpful change in the future. Andrew?
Yeah, I agree with everything you just said, especially in terms of taking things off the table. I think that may be a bit of I think it could be a double-edged sword if it were to happen, and depending on what the case is. But in any high stakes controversial case that has sort of large public policy implications, there's going to be a winner and a loser on either side. And so I don't see, even if there's a decision taking something away from the courts, there's going to be probably renewed push from the people who don't want it taken away from the courts to be putting up judges who are going to want to put it back in the hands of the courts. So I think there's almost even no way, once the cat's out of the bag, to put it back in. In terms of the filibuster, I think one of the things you pointed out, and I'll sort of flesh out the mechanics of it, I think it's a very good point and something that could change. In the past, you had what's called post-closure time, which is you have to spend 30 hours of floor time, which is a lot of time, which prevents the party that controls the floor from doing other things they want to do. And floor time is very precious. You have a lot of things you need to get done. You have nominations, you have bills, you have resolutions that you want to put out. So every minute that you're spending on one thing isn't a minute you're not spending on something else. And when you file a cloture petition, that's the end debate, that's the filibuster. You then have to spend time after cloture is invoked before you can actually have the final vote. And that used to be 30 hours for all nominees to the judiciary. That changed, and I believe it was 2019. That changed for district courts from 30 hours to 2 hours. And that was a function of the fact that back in the day, there weren't filibusters on basically any judges. And now you were getting filibusters on all the Trump nominees who were for the district court. It made it completely unfunctioning for the Senate to be able to process all the nominations of district court judges and still be able to conduct its regular business if you have to burn 30 hours of time after every single district court judge. Texas, if I remember correctly, put 20, Trump nominated 20 and confirmed 20 judges, I believe, to the Texas district courts. And you'd have to burn, 20 times from 30 hours. That's a lot of time, right? And you're going to have to spend. The circuit nominees are still 30 hours. It's not 2. But consider whether in the future, with filibusters, if you have a party that is wanting to get more things done, whether they reduce that time to try to expedite and move circuit judges even faster. So that's something that could change. As I mentioned, the blue slip is something that could change. As Judge helpfully pointed out, the senators jealously guard their prerogatives in terms of being able to pick nominees that they support. It's a benefit of being a senator is you get to pick nominees for judicial positions, for U.S. attorney positions. It's an important thing. As people know, in Washington, personnel is policy. So getting the right people is incredibly important. And there's going to be there could be a push to remove the blue slips such that senators don't have the ability to veto effectively district court nominations from a president. But it's a double-edged sword for them too, because if you give away that power in order to get more, say you're a Democrat today and you get rid of the blue slips in order to make sure that President Biden can fill seats in the Republican administration, fill seats in red states. Well, it's also possible that President Biden and the administration don't like your pick for who you want to be the judge in your state. And so they steamroll you. So you're giving away power against even a friendly administration for you. So I'm not sure whether they would do it, but it's something that could be on the horizon. And you can think about whether that's positive or negative in terms of the judiciary as a whole, but it's something that certainly could happen. And the last thing I'll mention is the ABA, which has for a long time been something that conservatives have been concerned about, that the ABA is not giving fair ratings and tries to puts its thumb on the scale against conservative nominees and favors liberal nominees. The ABA took a lot of hits during the Trump administration from the Republican side of the aisle. And I think they still do their nominations. They still have special access to the nominees in order to make their recommendations as in terms of someone who's well qualified or not qualified. But I see them being less involved in the process in the future, as Republicans have lost faith, or even less faith in them than they used to. And I think they're seen as more polarized, and I doubt they're going to have as much influence in the coming years as they once had.
All right, and with that, we will transfer to the questions portion. So if y'all have any more questions, please put them in the chat. But to start the question and answer period, Andrew, I know you wanted to talk a little bit about the judicial nominations process, specifically as it relates to Texas. Could you talk about that a little bit?
Sure. I thought some folks may be interested in the way that the senators in Texas actually do it, because, as I mentioned, different states do it in different ways. The way Texas does it is through a federal judicial evaluation committee. So it's a bipartisan committee that meets every so often about nominees, both U.S. attorneys, district court judges, and circuit court judges. And it's a mixture of lawyers from across the state. There are folks from El Paso, from behind the pine curtain, so to speak, in East Texas, from my hometown up in Lubbock, and down to the Rio Grande Valley. And they all come from different walks of life, different practices, whether some are at major firms, some are at smaller firms, some are transactional attorneys, most are litigators. And so everyone who wants to be a U.S. attorney or a judge, when there comes in a position open, they have to submit their materials to the committee. That funnels through us. We end up getting us being staff receives the applications, processes them all, sends them out to the FJEC, as we call it, members, who then sort through all the papers and decide who they want to interview. And they will then call certain individuals for interviews. They sit there, interview them, ask them whatever questions they want. At the end of the day, they make votes and recommendations to the senators. The senators then make decisions. They'll interview certain candidates based on recommendations, taking that into account, and they'll make decisions together. Senator Cornyn and Senator Cruz will. They will hash out who they like, who they want, who they think is the best fit, and then they'll work with the White House to get those people nominated. In the Republican administration, with the Trump administration, the senators basically put together, if I remember correctly, one name for each seat. They came to agreement and they said, here's who we want. And of course, Senator Cruz and Senator Cornyn didn't always agree on the best person for any individual seat. So there was, they would have compromises in terms of, they all liked them all, but you would have, Cruz says, I would really like this person for this seat, and Cornyn says this one for this one. And they make some sort of arrangement where they can all support the package. They then work with the White House, and the White House would nominate. This is going to be different in the Biden administration as it was in the Obama administration, because the senators' main picks that they would like are not going to be the same people who the Biden administration is going to want. So we'll see how that works out in terms of negotiating and figuring out who the best judges are for the state of Texas. But that's effectively how the process works in order to try to get the best nominees, because we believe that the FJEC process is a way to sort out with a panel of really great lawyers a set of nominees who are going to be very good, understanding of judicial temperament, smarts, experience, all the things you want in a good judge. They'll be able to put forward to get the best nominees for Texas.
Great, thank you. And Judge, I wanted to follow up on something that you mentioned, which was that and as this process continues to develop and unfold, that it might be the case that you need some quote unquote ideological credibility with the side that's in control to be a judge. So from your perspective, if you were going to give advice to say some young law students who may at one point want to become a judge, how would you recommend maybe going about that, or just generally what kind of advice would you have for them?
Well, since it took me so long to get my nomination, I'm not sure I'm a good person to be giving advice. But just looking at the people, let's say under President Trump, who were named, a former law clerk of mine is a district judge now in Jackson. And in the 3 states of the Fifth Circuit, district judges and circuit judges, I know more maybe about them, at least recollection of them. I do think it's important to be a good lawyer, doing good work, but joining groups, no matter what profession you're talking about, and getting yourself known and getting respected because of who you are and what you're willing to do, is important. But I did see in the selection of some of the judges in the last 4 years, and I expect it's happening now, to have some credibility among those who are making the final selection is important. So I don't know if I have any particular recommendation, but the Federalist Society, to me, certainly not to people, to some people, but to me, it's an extraordinarily useful, helpful, important organization. When I was in DOJ so many years ago, I first became aware of the Federalist Society because the Assistant Attorney General, somebody who had a title 1 word shorter, higher up the chain, was an active member, and we would go to meetings at some Chinese restaurant, which is probably not where they meet anymore. And there was a little corner where the speaker would be that was very dark. I never understood why that's where the person spoke from, but it was just fascinating. And so I wouldn't get involved in something because it might help you in the future. I'd get involved in something because it's interesting to you, because you believe in it or want to learn about it. And that was one of the great things about the Federalist Society. We're not having a debate tonight, but they certainly have a reputation for having debates of different viewpoints. So I think it is maybe not uniquely credible in my perspective as a group to become involved in, but it is one of the excellent ones. But whether it's writing or whatever else, but the flip side is it can make you a target for those opposed to that point of view. So that's why I'm saying I wouldn't press it too hard, but I would not hide your light under a bushel basket.
I'll jump in and also say that there's a saying that it's like getting struck by lightning to become a federal judge, and I would advise anyone who's interested in it that don't plan your career around it. Do what's interesting to you. Do what is meaningful to you. Do what makes you have a fulfilling career, assuming that will never happen, because you never know. You have so many great lawyers who would make fantastic judges, but the opportunity never arises for them, whether that's because they're of the wrong age when the administration that would be friendly to them is in power, or whether that's because the senators in their state are not ideologically aligned, or whatever the case may be, or whether it's you kept your nose clean and didn't write anything to sort of follow the Roberts mold, so to speak, and then the process changed, or then you decide to be outspoken because you think that you need to show your bona fides, and then the process changes again, and that's no longer what's getting people to judgeships. It's an open process, and every senator cares about different things. Every administration cares about different things. The timing of when vacancies occur is very random. So just do what you can to have a fulfilling career, work hard, and if it comes, it comes. But if it doesn't, you want to have a fulfilling career regardless.
If I could just close if it's time, but add one thing to what Andrew said. Absolutely correct what he's saying. But I would also say, if you really want it, make sure you're doing something else and have a path that's going to keep you involved and pleased and fulfilled to the extent possible. But if you want to be a federal judge, just be persistent, and maybe it'll happen one day, and it won't happen the first time you might have been considered, but it might happen a later time. I basically was considered 3 times, nominated twice, and it finally worked out, at least for me. I hope it worked out for the Fifth Circuit as well. But nonetheless, I would just add on top of what Andrew said is if you really want it, make sure it's not all you're doing, but you can, if you stay persistent, lightning does strike.
Indeed.
That's great.
Well said, Judge.
Awesome. Well, Judge, Mr. Davis, thank you so much for joining us at this event. It's been a pleasure and an honor to have you guys here. So I know that, normally we would all clap and say thank you, but we're all virtual. So virtual claps all around. So thank you all for being here. And remember, if you're not already a member of the Federalist Society, please go to texasfedsoc.org to join and check out the chat for next week's event, Big Tech in Section 230. Don't miss that.